Picture this. You're part of a Latin American law firm advising a U.S. company on a major infrastructure deal. The Miami office sends new instructions. Please tell your team to adjust the compliance clause according to U.S. standards. You can't just forward that message word for word. Instead, you respond professionally. The Miami office requested that we adjust the compliance clause to meet U.S. regulations. That's reported speech, the way lawyers communicate instructions clearly and diplomatically across offices and time zones. Later, you prepare a summary for the client. Instead of writing, we agreed to change the clause, you make it sound more formal and concise. The modification of the compliance clause was approved by both parties. That's nominalization, transforming verbs into nouns to create precise professional writing. And this is daily reality for lawyers working across the globe. Every message, memo, and summary must sound clear, objective, and legally accurate, especially across borders. In today's lesson, you'll learn how to use reported request and nominalization naturally in cross-border communication, helping you write and speak with the confidence of a truly international lawyer. In this lesson, you'll develop two advanced communication skills essential for lawyers working in international teams. First, you'll learn to use reported request and indirect speech, structures that help you sound diplomatic and precise when passing information between clients, colleagues, and offices. For example, instead of quoting a client directly, you might say, "The U.S. partner requested that we revise the draft before filing." This structure keeps your message formal and professional. Second, you'll practice nominalization, which transforms actions into formal nouns, a key feature of professional legal writing. For instance, the decision to postpone negotiations sounds more objective than "we decided to postpone." We'll also explore essential teamwork vocabulary used when coordinating with lawyers abroad. Terms like jurisdictional conflict, due diligence report, and client instruction. By the end of this lesson, you'll be able to communicate complex legal updates, summarize meetings, and write reports that reflect the tone and precision expected in cross-border legal practice. Imagine a Monday morning video call between a firm in Bogota and their partner office in Houston. The two teams are finalizing a joint venture agreement for a renewable energy project. During the meeting, the American client says, "Please make sure your team removes the arbitration clause. We prefer mediation." The Colombian associate later emails the local team. "The client said we must delete the arbitration clause." But when the email reaches the client's in-house counsel, tone sounds too strong, almost like an order, not a preference. In the next meeting, the partner clarifies the message more diplomatically. The client requested that we consider removing the arbitration clause and replacing it with mediation. That subtle shift, using reported speech, changes the tone from direct to professional. Later, when summarizing the outcome, the associate writes, "Following the discussion, the modification of the dispute resolution clause was approved." That's nominalization in practice, transforming an action into a formal statement suitable for a client report. This story shows how grammar choices can affect meaning, professionalism, and trust when lawyers work across borders. Cross-border coordination is one of the most challenging aspects of international legal work. It means ensuring that every team involved, often from different countries and legal systems, works under the same timeline and strategy. For instance, in a Latin American merger with a U.S. investor, one team might handle tax filings, while another reviews corporate compliance. Both teams must constantly exchange drafts, reports, and client updates. This term also reflects how communication styles differ. In some cultures, feedback is softened. In others, it's more direct. Lawyers must adapt tone without losing clarity. The example sentence shows how responsibilities are divided geographically. One firm manages local law, another oversees the global structure. Successful cross border coordination depends on accurate reporting, consistent terminology, and professional English that bridges linguistic and cultural gaps. A jurisdictional conflict arises when two or more countries could legally decide the same matter. In cross border disputes, like a breach of contract between a U.S. investor and a Brazilian manufacturer, both sides may argue that their local court is the proper venue. Understanding this term is vital for lawyers advising international clients. The key questions are: which country's law applies, and where should the case be filed? To prevent such conflicts, contracts often include choice of law and forum selection clauses. In the example, the U.S. and Brazilian courts may both claim competence. A skilled lawyer would examine treaty provisions, arbitration clauses, or conflict of law principles to determine jurisdiction. In practice, resolving jurisdictional conflicts demands precise English. Lawyers must explain complex procedural concepts clearly to foreign clients unfamiliar with the system. In international practice, a client instruction is more than a casual request. It's a binding guideline for legal work. Lawyers document and confirm each instruction carefully to avoid misunderstandings, especially across borders and languages. For example, if a U.S. company tells its Latin American counsel to finalize a joint venture agreement before quarter end, that instruction sets both a legal and commercial timeline. A single mistranslation or assumption could cause delays or noncompliance. Lawyers often rephrase instructions in writing to confirm understanding. For example, we understand your instruction is to revise the confidentiality clause before execution. This polite confirmation shows both professionalism and it also protects both sides. In international teams, proper management of client instructions demonstrates diligence and accountability, traits that build trust with multinational clients who expect efficiency, clarity, and precision. A legal memorandum, or memo, is the backbone of professional written communication in law firms. It explains the laws, applies it to the facts, and concludes with practical advice. In international teams, memos ensure everyone, from partners to junior associates, interprets the law consistently across jurisdictions. For example, a Costa Rican associate may draft a memo comparing local data protection laws with U.S. standards under the GDPR model. This memo helps U.S. counsel understand local compliance risks before advising the client. Writing a clear memo requires objective tone, structured reasoning, and precise language, skills that are strengthened through nominalization and reported speech. Instead of writing, "We checked the law and found differences," lawyers say, "The review identified key regulatory differences." Memos like this transform complex legal issues into actionable insights, supporting collaboration between regional and international offices. A due diligence report is one of the most important documents in cross border transactions. It summarizes what lawyers, accountants, and consultants have discovered about a target company's legal and financial situation. In an international merger, this report ensures that both sides understand potential liabilities before signing. For instance, if a U.S. investor acquires a company in Colombia, the local legal team reviews labor contracts, tax filings, and environmental permits. Their findings are compiled into a due diligence report, which is then sent to U.S. counsel for review. The report's tone is factual and analytical, often written using nominalization to sound objective. The review revealed noncompliance with tax reporting requirements. In cross border teams, due diligence reports prevent surprises, support negotiation strategy, and serve as formal records of professional investigation. A legal opinion is the product of expert analysis, a lawyer's official statement confirming how the law applies to a specific situation. International transactions often require legal counsel to issue legal opinions to reassure foreign investors. In the example, Mexican counsel confirmed the enforceability of a contract under national law. That written opinion allows the U.S. client to proceed confidently, knowing the document meets local legal standards. Legal opinions must be precise, neutral, and evidence based. They typically use nominalized expressions such as the validity of the transaction or the interpretation of the clause to sound formal and impersonal. In cross border practice, a single legal opinion can determine whether a deal closes or fails. Lawyers must therefore communicate their reasoning clearly, not just in legal terms, but in English that is both accurate and internationally understood. A non disclosure agreement, or NDA, is essential in international collaboration. It ensures that sensitive information exchanged between teams remains confidential. When firms in different countries share client data, financial records, or drafts, they first sign an NDA to prevent unauthorized disclosure. In the example, two firms, one in Chile, another in Texas, sign an NDA before beginning work. This step allows open communication while protecting intellectual property and client privacy. NDAs are written in highly formal English, often using legal phrases such as the obligation of confidentiality shall survive termination of this agreement. Lawyers must understand the nuances of such language, as it defines both legal and ethical duties. In global teams, NDAs build trust. They assure clients that professional communication will remain secure, even across borders and time zones. Time zone management may sound logistical, but it's a crucial part of cross border legal work. International teams must coordinate across several time zones, for example, between Costa Rica, New York, and Madrid, to meet filing deadlines and client expectations. In the example, good planning and clear communication allowed both offices to finish the work despite the 6-hour time difference. Lawyers use shared calendars, rotating schedules, and detailed email summaries to maintain productivity. Mismanaging time zones can cause late filings, missed calls, or duplicated work, all of which damage client confidence. That's why clear written communication using reported requests, for example, the partner asked that the draft be completed before 5 p.m. New York time, keeps teams synchronized. Successful time zone management demonstrates professionalism and adaptability, essential qualities in the modern global legal environment. In international teams, information constantly moves between offices, clients, and partners, and lawyers must pass it on precisely without changing the tone or meaning. That's where reported requests and indirect speech become essential. Instead of quoting someone word for word, we rephrase the message politely and professionally. For example, the direct instruction, please review the agreement, becomes, she asked me to review the agreement. This structure keeps the tone formal and neutral, perfect for emails or meeting notes. We often use verbs such as ask, request, tell, or instruct when reporting what colleagues or clients said. For example, partner requested that we revised the clause. They told us to submit the draft by Friday. Notice that in reported speech, the verb tense often shifts back. The client said he needed more time, reflecting that the original statement occurred earlier. Mastering this skill helps lawyers summarize meetings, forward client instructions accurately, and avoid misunderstandings in multilingual, multicultural teams. In professional legal English, we often transform actions into nouns, a process called nominalization. This makes writing more formal and analytical, which is essential in contracts, memoranda, and reports. For example, the direct statement, "We decided to terminate the contract," sounds conversational. When we change it to, "The decision to terminate the contract," the tone becomes objective and suitable for a legal document. Similarly, "The parties agreed to modify the clause" becomes, "The modification of the clause was agreed upon by the parties." Nominalization helps lawyers focus on the result of an action rather than who performed it. This reduces personal tone and increases neutrality, an important feature of international communication. In multicultural teams, using nominalized forms avoids misunderstandings caused by overly direct phrasing. It also allows for smoother translation and consistency across documents. You will see this structure everywhere in professional legal English, in due diligence reports, legal opinions, and client updates, because it gives writing authority and precision. In international legal teams, tone and clarity matter as much as accuracy. Lawyers often rewrite simple sentences into nominalized forms to sound more formal and impersonal, perfect for memos, reports, and client summaries. Let's analyze the first example. "We analyzed the contract and found errors." That's fine in conversation, but in writing, we say, "The analysis of the contract revealed several errors." The verb analyzed becomes the noun analyst, shifting the focus from the person to the result. Next, "They approved the merger last week" becomes, "The approval of the merger was granted last week." This turns a direct action into an objective record, suitable for reports or press releases. The same happens with "the client requested to delay the closing." A lawyer might write, "The client made a request for a delay in the closing." Nominalization standardizes language, removes unnecessary repetition of subjects, and creates that professional distance expected in formal legal communication. When you draft your next memo, try rewriting active verbs into nouns. You'll instantly sound like an international practitioner. The phrase "circulate for review" is used constantly in international legal teams. It refers to sending a draft, such as a contract, memo, or due diligence report, to others for comments before finalization. For example, in a cross-border merger, the Mexico City office may prepare the first draft. Once complete, it is circulated for review to New York and Sao Paulo to ensure accuracy across jurisdictions. Each office adds comments, suggests edits, or flags local compliance issues. This process reflects how international law firms maintain quality control and accountability. The phrase also signals a stage of workflow. It's more formal than "send for comments" and conveys professionalism in email communication. Lawyers often write, "Please find attached the updated draft, circulated for your review and feedback by Thursday." Knowing when and how to use this phrase shows you can manage document flow and deadlines efficiently in multinational teams. To mark up a document means to edit it directly, highlighting additions, deletions, and comments, usually using the Track Changes function in Word. This is one of the most frequent tasks for lawyers collaborating across borders. In the example, the partner asked the associate to mark up the confidentiality agreement, meaning they should suggest edits, not finalize the document. It's a stage of internal review before sending it back to the client. Markups are a universal language in law firms. They allow US, Latin American, Arabic, and European firms to communicate edits visually, reducing confusion over complex clauses. When reporting progress, lawyers often write, "I've marked up the draft to reflect our local requirements." The key skill is using neutral, clear comments that explain changes without personal tone. Proper markup etiquette and understanding phrases like this is what keeps multinational collaboration smooth and transparent. A follow up communication is more than a polite email. It's a professional record of what was discussed, agreed, or requested. After meetings, lawyers summarize main points, assign responsibilities, and confirm deadlines. For example, following a client call about a cross border financing deal, the associate might send an email saying, "As a follow up, please find below the list of action items discussed." This ensures everyone, whether in Miami, Bogota, or Madrid, is aligned. Follow ups also demonstrate reliability and attention to detail. An international practice where time zones and language differences can create confusion, this written recap reduces the risk of misunderstandings. Lawyers use reported speech and nominalization naturally here. The client requested that we prepare the draft by Friday, or the decision to proceed with mediation was confirmed. Professional follow up communication builds accountability and trust, the cornerstones of successful international teamwork. To finalize for execution means a document is ready to be signed. All drafts reviewed, all comments incorporated, and all parties in agreement. This phrase marks the final stage in a long drafting process that may involve several offices and several languages. In the example, the client has approved all last minute revisions, so the team finalizes the contract for execution. It's a formal way of saying, "We are ready to sign." This phrase appears frequently in correspondence and cover emails. For example, "Please confirm that the version attached is finalized for execution." It ensures that everyone understands no further edits are expected. In transactions, clarity here is critical. A misunderstanding about whether a draft is final or executed can lead to serious legal or reputational consequences. Using finalize for execution reflects mastery of professional legal English, concise, procedural, and universally recognized among international counsel. Let's close with a story that mirrors real international teamwork. A law firm in Mexico City is assisting its U.S. partner in a cross border merger between a Latin American tech startup and a New York investor. The client's instruction is simple: make sure both jurisdictions approve the transaction this quarter. The Mexican associate summarizes it diplomatically in an update. The client requested that both teams complete the local filings before March 31st. That's reported speech: precise, respectful, and professional. Next, the draft share purchase agreement is circulated for review among offices in Houston, Bogota, and San Jose. Each team marks up the document, adding comments to reflect local regulations. A due diligence report reveals minor tax issues, which are addressed through coordinated communication. After the last video call, the lead associate sends a follow up communication confirming all next steps. The memo concludes, "The approval of the transaction was granted, and the agreement has been finalized for execution." This story shows how every element, clear English, formal writing, structured grammar, and precise legal phrases support cross-border success. In this lesson, you explored how international legal work depends on clear communication across languages, cultures, and jurisdictions. You mastered vocabulary that lawyers use daily in cross border projects. Terms like jurisdictional conflict, client instruction, due diligence report, and legal memorandum. These words help you describe complex professional activities precisely. Then we focused on grammar that reflects professionalism, reported requests, and indirect speech, the key to relaying information accurately and respectfully between clients and offices. Nominalization, turning verbs into nouns to create a formal and personal tone in legal writing. We also examine technical phrases, circulate for review, mark up a document, follow up communication, and finalize for execution that appear in real legal workflows worldwide. Finally, through the merger story, you saw how clarity, tone, and structure can prevent misunderstandings, maintain trust, and close deals efficiently.